Employers might hire a mediator if two employees are not getting along or if groups of employees aren't getting along in the workplace. In other situations, an employee might file a complaint with a government agency or with a court, and mediators can help resolve those complaints and lawsuits. Examples of the kinds of claims that can be resolved in mediation include everything from wage and hour claims, sexual harassment claims, disability accommodation claims, disputes over non-competition agreements, and any other kind of employment-related dispute. Unions and management also use mediators to help resolve grievances and also to help if they can't settle terms on their own in a collective bargaining agreement. Generally, parties have the opportunity to provide a mediation statement or submission in advance of the mediation for the mediator's review. That can be a copy of the complaint and a copy of the response. It can be letters from each party explaining the issues and the claims involved in the case to give the mediator some background. Sometimes people will offer some key documents for the mediator to review in advance of the mediation as well. Parties should also be thinking about and getting information on the risks and costs of the ongoing dispute, whether that be litigation or otherwise. Mediation presents an opportunity to get some things that you can't get in a court or other kind of process. For example, employees sometimes can get letters of reference from the employer through a mediation. They can also get things like improvements to policies that the employer has or training for supervisors. Employers should also consider that there are things they can get during mediation that they can't get through a court process or arbitration or other process. For example, confidentiality of the settlement terms and non-disparagement provisions that would require the employee to not say bad things about the employer, its owners, or any of their employees.